Okay, today's lesson is on the process and a little bit about the history of Supreme Court nominations. I want to focus especially on one of the most controversial of Supreme Court nominations, and even in a recent one that was also very, very controversial. This is a slightly outdated picture. There isn't a picture yet of the new Supreme Court with the 9th member. Breyer retired there on the bottom right, so there will be a new picture next time. So the nomination and confirmation process is set out in Article 2, Section 2 of the Constitution, and it states that the President shall nominate and by and with the advice and consent of the Senate shall appoint judges of the Supreme Court. Very simple explanation, not a lot of detail, but that's the basic rule. This is a nice little overview of the process. So the first step is nomination, then there's vetting, first hearing, that's in the Senate Judiciary Committee, then a committee vote, then a debate on the Senate floor, and then there's the possibility, there was, of a filibuster. The filibuster is now dead, so you don't need a vote for cloture. And then a final vote, and then confirmation, if indeed the person is confirmed. So the president will usually consult with senators before announcing a nomination. When the president nominates a candidate, the nominee or the nomination is sent to the Senate Judiciary Committee. The Senate Judiciary Committee holds a hearing. The committee usually takes a month to collect and receive records from the FBI and other sources about the nominee, and for the nominee to prepare for the hearings. During the hearings, witnesses for and against the nominee can present their views, and senators usually question the nominee about his or her qualifications, judicial philosophy, and so on. The Judiciary Committee then votes on the nomination and sends its recommendation that it be confirmed, rejected, or no recommendation to the full Senate. The full Senate then debates the nomination. The Senate rules used to allow unlimited debate. This was the filibuster. And to end the debate, it required a cloture vote. And that required 3/5 of the senators, or 60 senators, to invoke cloture and end a filibuster. But in 2017, the Senate changed this rule and lowered the required votes to 51 to end debate, a simple majority vote. When the debate ends, the Senate votes on the nomination. A simple majority of the senators present and voting is required for the judicial nominee to be confirmed. If there is a tie, the vice president casts the deciding vote. How long does it take to confirm a Supreme Court justices? This chart shows you that in 8 instances, a Supreme Court justice has been nominated and confirmed on the very same day, but that doesn't happen anymore. In 2 cases, it took over 100 days. But in the majority of the cases, you can see they fall somewhere in the middle. Historically, 19 cases took 1 or 2 days, 36 cases took 3 to 10 days. That was back in the 1800s, mostly early 1900s, when the process was a lot easier. Lately, they can take 11 to 20 days, 21 to 30 days, even 76 to 100 days. 10 of them have taken that many days. That's over 3 months, right? 2 or 3 months. Now, the amount of time that it takes has been increasing over time. In other words, it takes longer now than it used to. You can see back in the early years, the 1700s up until about 1860, at the bottom of this chart, it always took less than 10 days, right? up until about 1860. You have one that looks like it took maybe 11 days. I was wrong. There was one in the early 1820s that took 30 days. There was an outlier, and one that took 80 days, so I was wrong. But rarely, the vast majority of them until the Civil War were nominated and confirmed within 10 days. But then they start to get longer, and the record was Louis Brandeis, and I'll talk about him in a minute. But then recent names, these are all people who were nominated and confirmed and are sitting on the court today. Alito, 82 days, Thomas, 99 days, Kavanaugh, 88 days, Kagan, 67 days, Gorsuch, 65 days, Sotomayor, 66 days. Breyer is gone, but he did take 73 days when he was nominated and confirmed. Recently, Amy Coney Barrett was nominated and confirmed within a month, but that was considered by some people to be rushed. Right? Back in the 1800s, that would have been considered a long time. Now it's considered rather quick. So a little bit about the history of this process. So as the first president, George Washington successfully appointed 10 justices to the Supreme Court. The only time the Senate rejected a Supreme Court nominee from Washington was when he tried to make this guy, John Rutledge, the Chief Justice. He was an Associate Justice. Washington wanted to elevate him to the Chief Justice position, and he was rejected because he had angered the Senate by opposing a treaty that the Senate was in favor of. The Senate had recently approved. The first president who encountered significant opposition to his nominees was this guy, John Tyler. He was an unpopular president. He was nicknamed his accidency by his critics because he had been vice president, the president had died, he had been elevated to the presidency, but he had never won the election to be president. And he alienated all of the members of his own party. He was a Whig, but the Whigs hated him, and so they refused to let him have the nominees he wanted. He nominated 5 men, only one of them were confirmed. As for the other 4, they either rejected them, they postponed the votes until he was out of office, or they just ignored his nominee altogether. In 1874, Ulysses S. Grant nominated this guy, Caleb Cushing, and his name was withdrawn. Cushing asked for his name to be withdrawn before there was even a vote. And the problem was, before the Civil War, or during the Civil War, while Jefferson Davis was the president of the Confederate States of America, Cushing had written an introductory letter to him. And this was considered too polite to an enemy of the United States during the wartime. Worse than that, he had also supported the Supreme Court's 1857 Dred Scott decision. If you're not aware of that decision already, it's almost universally considered the worst or one of the worst Supreme Court decisions of all time. It was a decision that said that Black Americans weren't and could not be U.S. citizens. And so his support for that decision was extremely unpopular with the Republicans in control of the Senate, and he knew he couldn't make it, so he asked to be withdrawn. This guy, Lucius Quintus Cincinnatus Lamar, was nominated by Grover Cleveland, who was the president and who was a Democrat in 1887. But his nomination was unpopular because he had been a colonel in the Confederate Army during the Civil War. He did pass. He did get his nomination approved of in the Senate, but it was a close vote. It was only 32 to 28, one of the closest votes in history for a judicial nominee. This is one of the easiest in history. Edward D. White was nominated by Grover Cleveland. He was a Democrat. And he was confirmed the same day in 1894. 16 years later, 1910, a different president, William Howard Taft, who was a Republican, nominated him to be Chief Justice. So he had been an Associate Justice for 16 years. He was being bumped up to become Chief Justice. Again, he was confirmed on the very same day. So he has a distinction of being nominated and confirmed on the same day twice. All in all, he served 27 years on the court. And this is just an excellent example how once upon a time, many years ago, the process was usually very uncontroversial. This is one of the last justices to be confirmed easily. His name is Byron White. He was confirmed in 1962 after an 8-day process that ended in a voice vote. Now, he makes a kind of nice dividing point because before him, most of the judicial nominees were approved really quickly, like he was, within a week or so, within 10 days or so. After him, things quickly became much more difficult. But I kind of have my chronologies out of order here. I probably should have mentioned this guy. Louis Brandeis was nominated in 1960 by Woodrow Wilson, Democrat, and he holds the record for the longest confirmation battle, 125 days. So that's 4 months that the battle raged whether or not to confirm his nomination. It was the first time that the Senate Judiciary Committee had public hearings on a nominee, which is very common today. For every time the hearings are public. This was the first. And the reason, basically, well, he might have been unpopular because he was a progressive, and so he had some opinions that were considered new and unpopular at the time. But he was also Jewish, and he became the first Jewish justice on the Supreme Court, and that was really the root of a lot of the controversy about his nomination. Earl Warren was put on the Supreme Court in the 1950s. Again, you can use him to divide the time frames between a nomination and selection. From the birth of the Republic in the 1790s up until his nomination, the average nomination and confirmation process took 13 days. From him until Amy Coney Barrett in 2020, the average was 54 days. So, 4 times as long?
His was 54.
I'm sorry?
His was 54.
No. His was easy. After him. If you just divide between before him and after him.
Yeah.
Before him, the average was 13. After him, 54. So, his was one of the easy ones. Do I want to go into this? Yeah, sure, why not? So I'll give you some more statistics. Between 1789 and 1965, there were 130 nominations to the court. Only 9 were rejected. $15 were withdrawn or something else happened. Over half, 68, were confirmed on a voice vote. A voice vote happens when it's so easy and obvious that the person is going to be confirmed that they just say yay or nay. They don't even need to take the time to write down each vote individually because they're expecting it to be, virtually unanimous. So that's kind of a symbol of how easy it once was. Since 1965, there have been 28 nominations. 7 failed. Actually, I should double check this. Let's say 28 or 29, because I can't remember if I updated this. Last year, there was a new person put on the court. Let's say 28 or 29. I might have forgotten to update it. Richard Nixon is another president who had trouble getting his nominees, 2 of them. The problem he ran into is he had promised when he was running for president to put a Southerner on the Supreme Court. I guess there hadn't been one at that time, or in a while, or there wasn't at that time. But he wanted to court some Southern votes. And he first nominated this guy, Clement Haynsworth. But it turned out that Haynsworth had supported a decision by Prince Edward County, Virginia in the 1950s to close its public schools rather than integrate them in response to Brown versus Board of Education. So civil rights activists criticized him, and he was rejected by the Senate. Then Nixon nominated Harold Carswell, and he had 2 problems. One, he was widely considered to be mediocre, just not an impressive mind, judicially. But worse, in 1948, he had given a pro-segregation speech to the Georgia legislature, or in running for the Georgia legislature. He had said, "I yield to no man as a fellow candidate or as a fellow citizen in the firm, vigorous belief in the principles of white supremacy, and I shall always be so governed." When this statement came to light, the Senate rejected him as well. So ties to segregation and white supremacy doomed to both of these candidates. The next candidate to inspire really, heated opposition is this guy, Robert Bork. And this is a key one, because here you see the beginning of the modern, controversial, heated process of judicial confirmations. Occasionally before, there had been controversial ones like Brandeis and the 2 that Nixon couldn't get on, but now it's almost all of them, right, are controversial in some way. So in 1987, President Ronald Reagan nominated Judge Robert Bork to be an Associate Justice of the Supreme Court. Bork's nomination precipitated a debate in the Senate. Opposition centered on his perceived willingness to roll back civil rights rulings of earlier Supreme Court decisions, and he had a small role in the Watergate scandal. To pro-choice legal groups, so the central issue is abortion, really, as much as anything. His belief that the Constitution did not contain a general right to privacy was viewed as a clear signal that if he was named to the Supreme Court, he would vote to overturn Roe versus Wade. He had said that. He had said in writings he didn't see a right to privacy in the Constitution. Roe versus Wade was based on the idea that there is an unenumerated, unwritten right to privacy in the Constitution. In other words, it's there even though it doesn't say it. And so people thought, well, if that's the way he feels, he's going to vote to overturn Roe versus Wade. And that was really why this was so controversial, and all of the others after him. Within 45 minutes of his nomination, Senator Ted Kennedy, a Democrat from Massachusetts, got on the Senate floor and condemned Bork. He said, "Robert Bork's America is a land in which women would be forced into back alley abortions. Blacks would sit at segregated lunch counters. Rogue police could break down citizens' doors in midnight raids, and school children could not be taught about evolution. Writers and artists could be censored at the whim of the government, and the doors of the federal courts would be shut on the fingers of millions of citizens." So it painted him in a pretty horrible light. The Senate went on to reject his nomination 42 to 58. 42 voted in favor of him, 58 against. And he's the most recent Supreme Court nominee to be rejected by the U.S. Senate. A few years later, this one became even more controversial, and maybe to this day the most controversial of all. Maybe the Kavanaugh one you'll see gives a close contest. In 1991, President George H.W. Bush nominated Clarence Thomas to replace Thurgood Marshall, who had announced his retirement. Now, Marshall was the first black person on the U.S. Supreme Court, and he was an icon of the civil rights movement. He had argued the Brown versus Board of Education decision as a lawyer. He had been the guy who argued and convinced the court to declare segregation in public schools unconstitutional, and then he had become a member of the Supreme Court later. So this nomination was contentious from the start, especially over the issue of abortion, and many women's groups and civil rights groups opposed him. And then, well, let me get into the details later. So here he is. Thomas was 43, and George H.W. Bush liked him a lot, had been eager to appoint him to the court even though he was very young, and saw this as the perfect opportunity to replace Thurgood Marshall, who was a very kind of liberal judge, with Thomas, who was known to be a very, very conservative judge. Here you see them talking again. So some of the groups that opposed Thomas, the NAACP, the Urban League, and the National Organization for Women, they were all opposed to him because they knew replacing Marshall with him would shift the balance in the court from left to right. And that's a good thing to remember when you ask yourself, why are some nominations more controversial than others? The ones that threaten to shift the balance one way to another are the ones that are going to be the more controversial ones. So Marshall was way over on the left of constitutional interpretation and politics. Thomas was way over on the other side of the spectrum, very, very conservative. So that's why people were so upset, right? People who opposed him and wanted to take him down and prevent his nomination from succeeding, because they didn't want that balance of power to shift on the court. So he had also criticized affirmative action, which Marshall had strongly supported. And he didn't have, if I recall, a public statement about abortion, about Roe versus Wade, but they were very skeptical of his stance on that as well. An African-American attorney who was an activist named Florence Kennedy said at a conference in New York City for the National Organization of Women, "We're going to Bork him." What does that mean? They're going to do to him what was done to Robert Bork. They're going to take the nominee down. So it was highly politicized, highly contentious from the very beginning. Shortly after, President Bush selected Thomas as the nominee, Democratic staffers on the Judicial Committee began hearing rumors that in the past he might have sexually harassed one or more women. And in early September, the chairman of the Senate Judiciary Committee, Joe Biden, pictured here, is now president, asked for an FBI investigation into the charges. The FBI interviewed the woman who ended up accusing him of sexual harassment, and they interviewed Thomas a couple of days later. The public confirmation hearings began on September 10th, 1991, and lasted for 10 days. The senators questioned him on his legal views, his speeches, his writings, the decisions he had made as a federal appeals court judge. And under questioning, Thomas repeatedly asserted that he had not formulated a position on Roe versus Wade or had any conversations with anyone regarding the issue. This is an interesting point in American political history and judicial history. 4 years earlier, when Robert Bork had been nominated by Reagan, the hearings were publicized, the hearings were contentious. He argued back and forth with the senators about the Constitution, about the law. He didn't hide his views. And that helped give his enemies ammunition. They knew what to, criticize him for. From now on, for the last 30 years, starting with Thomas, all the judicial nominees, whether Republican or Democrat, followed the same script. They all refused to say anything. If the judges asked them, what are your feelings about Roe versus Wade? What are your feelings about the Second Amendment? What are your feelings about freedom of speech? They would all say either, I have no opinion, or I refuse to comment on any potential legal case that might arise. Meaning I refuse to, and the stance was, I don't want to prejudice myself by giving you an opinion now before I've seen a case, right? And essentially saying nothing. And that's been the pattern to this day. Well, on October 6th, after the conclusion of the hearings, and while the full Senate was debating whether to give final approval to the nomination, NPR, that's the radio program, the public radio, Supreme Court correspondent Nina Totenberg aired information from a leaked FBI report stating that a former colleague of Thomas's named Anita Hill accused him of making unwelcome sexual comments to her while they were working together at the Department of Education and then later at the Equal Employment Opportunity Commission. Once the story aired, Joe Biden, who was the chairman of the committee, came under intense pressure to reopen the hearings. The hearings were closed and it was ready to move on, right? And he did. The final Senate vote was postponed and the confirmation hearings were reopened. Hill was called to testify on October the 11th. She had worked as an advisor to Thomas at the U.S. Department of Education. And then when he became chairman of the U.S. Equal Employment Opportunity Commission, the EEOC, she followed him and worked there with him for a year before resigning in 1983. She claimed in 1991 in this testimony that while she was employed under him, working for him, he made sexually provocative statements. She said she followed him from the one job to the other anyway, because she thought at that time that the pattern of statements was ended, that he wasn't going to keep making these sexual overtures to her. She provided lurid details about his alleged behavior. She said he spoke about acts that he had seen in pornographic films. On several occasions, Thomas told me graphically of his own sexual prowess, things like that. I won't give you the gory details. You can find them for yourself if you want.
I got a question. Were they any about her? If not, then you want to say something about it if it wasn't about her. Maybe she might.
The statements that she said were statements that would be considered sexual harassment today if they happened. He obviously denied it because they would constitute, what's the legal phrase for it? A hostile work environment, right? And that would be the allegation. Not that he said anything directly to her about her body or her appearance or threatened her if she wouldn't go out with him, but that he would talk about things in a way that made her uncomfortable and that he knew or should have known was making her uncomfortable. I think that's the gist of the allegations. And that's a great question because at this point I should probably point out, this was really the beginning of national awareness of sexual harassment in the workplace. The whole topic kind of goes back to this event and people talking about it really for the first time. I don't mean that it had never happened before, that's obvious, but this was the first time you had a nationwide conversation about the issue. So, there were two women who made statements in support of Anita Hill, who was the accuser. One was Angela Wright. She said that Thomas repeatedly made, now she didn't say that she had seen Thomas saying these things to Hill. That's an important distinction. She didn't say she had witnessed him saying things to Anita Hill, the accuser. She said he had made comments like those to her also. She said Thomas had repeatedly made comments to her, much like those he allegedly made to Hill, including pressuring her for dates, asking her the size of her breasts, and frequently commenting on the anatomy of other women. Wright said that after she turned Thomas down for a date, he began to express discontent with her work and eventually fired her. He said he fired her for poor performance and for using a homophobic slur or epithet. Another woman named Rose Jordan corroborated Wright's statement, saying Wright had spoken to her about Thomas's statements at the time they were allegedly made, and that Wright became increasingly uneasy around Thomas because of his constant commentary about her body and looks, and that Wright once came to Jordan's office in tears as a result. I'm not sure, I just haven't studied the record enough to remember clearly if the second woman is saying she witnessed the comments herself or witnessed Wright's reaction to the alleged comments, if you understand the distinction.
She may be implying that she heard him talking to other people about the comments, or speaking to other men about the comments and might have overheard.
Well, what she clearly said was she saw Wright. Now, neither of them knew Anita Hill, but she saw Wright and how distraught she was after dealing with Thomas. I'm not sure if she's saying that she saw the episodes themselves or the reaction in the aftermath, but either way, she was there to support the other woman. Okay, Clarence Thomas testified, and you can see this on YouTube. This is one of the more dramatic events in American political history in the last, several decades. Thomas testified that the accusations were false, and that I deny each and every single allegation against me today that suggested in any way that I had conversations of a sexual nature or about pornographic material with Anita Hill, that I ever attempted to date her, that I ever had any personal sexual interest in her, or that I in any way ever harassed her. Complete denial, right? He's basically saying she's a liar. He said, this is a case in which this sleaze, this dirt, was searched for by staffers of members of this committee. It was then leaked to the media, and it was. That was interesting. Somebody leaked a confidential FBI report to the media. And this committee and this body validated and displayed it in prime time over our entire nation, and he called the hearing a high-tech lynching. He said, this is not an opportunity to talk about difficult matters privately or in a closed environment. This is a circus. It's a national disgrace. And from my standpoint as a Black American, it is a high-tech lynching for uppity blacks who in any way deign to think for themselves, to do for themselves, to have different ideas. And it is a message that unless you kowtow to an old order, this is what will happen to you. You will be lynched, destroyed, caricatured by a committee of the U.S. Senate rather than hung from a tree. Several women who had worked with Thomas and Hill at the EEOC testified from October the 11th to the 13th in support of Thomas. Also, records were introduced showing that Hill and Thomas had stayed in touch and had had dinners together and phone conversations for several years after she stopped working for him. And this was meant to suggest, according to people who were skeptical of her accusations, that they were really friends and then she was making the stuff up afterwards. This is J.C. Alvarez. She was one of the women who supported Thomas. She said, the Anita Hill I knew before was nobody's victim. She said, Thomas demanded professionalism and performance. He would not tolerate the slightest hint of impropriety, and everyone knew it. She asserted that Hill's allegations were a personal move on her part to advance her own interests. Women who have really been harassed would agree. This is her statement, sorry. She said, women who have really been harassed would agree if the allegations were true, you put as much distance as you can between yourself and that other person. What's more, you don't follow them to the next job, especially if you're a black female, Yale Law School graduate. Let's face it, out in the corporate sector, companies are fighting for women with those kinds of credentials. Nancy Fitch also worked at the EEOC. She said there is no way Thomas Dill did what Hill alleged. I know he did no such thing. As I told the FBI agent who interviewed me, I trust Judge Thomas completely. He has all of my support and caring earned by 9 years of the most positive and affirmative interacting, not only with me, but with other staff and former staff, men and women. Here you see some other women who testified on his behalf. Diane Holt is the second woman from the right. She said, at no time did Professor Hill intimate, not even in the most subtle of ways, that Judge Thomas was asking her out or subjecting her to the crude, abusive conversations that have been described. Nor did I ever discern any discomfort when Professor Hill was in Judge Thomas's presence. On the far right is Phyllis Berry Meyer. She said that Thomas was respectful, demanding of excellence in our work, cordial, professional, interested in our lives and our career ambitions. Her impression was that Anita Hill desired a greater relationship with Judge Thomas than just a professional one. Here are some of the other women who testified on his behalf. One of them was named Nancy Altman. She said it is not credible that Clarence Thomas could have engaged in the kinds of behavior that Anita Hill alleges without any of the women who he worked with, dozens of us. We could spend days having women come up, his secretaries, his chief of staff, his other assistants, his colleagues, without any of us having sensed, seen, or heard something. So in other words, she thinks she would have known, and she didn't. So there was, as you can see by the snippets I've read to you, there was tons of conflicting information about what really happened between those two people. So the vote went forward, and the Senate voted 52 to 48 on October 15th, 1991, to confirm Thomas as an Associate Justice of the Supreme Court. He won with the support of 41 Republicans and 11 Democrats. 46 Democrats and 2 Republicans rejected his nomination, voted to reject his nomination. The whole thing took 99 days. This is one of the longer Supreme Court battles in American history. It was so close that Dan Quayle, who was the vice president, was there that day. You can see him sitting in the chair there in the center to preside over it so that he could cast the deciding vote if there was a tie. He was ready for that eventuality. I won't go into nearly as much detail, but in a sense, in some weird ways, 25 years later, history seemed to repeat itself, although in this time maybe nastier, much nastier, really. Brett Kavanaugh was nominated by President Trump in 2018. He was also nominated to replace someone, not a liberal justice, but he was nominated to replace Justice Anthony Kennedy. And what was interesting about Kennedy's case, Kennedy was a Republican. He was nominated by a Republican. He was considered conservative in many of his decisions, but in some of them, like a crucial abortion decision, he had voted with the liberal wing of the party and upheld a right to abortion, upheld the essence of Roe versus Wade. So with Kennedy retiring and a known conservative like Kavanaugh being nominated to take his place, there was all kinds of energy and people who were opposed to the nomination because they sensed that this was a real threat to the constitutionality of abortion. Well, what's interesting, in echoes of the Clarence Thomas case, the Senate Judiciary Committee questioned him, heard witnesses, had a 4-day hearing, and then after the hearing, it was revealed that someone had accused him of sexual assault. And then there was a outcry, and there was controversy. There was just even more so now that we have the internet, and there was pressure to reopen the hearings. So they did. And then in highly dramatic form, both Brett Kavanaugh and the woman who accused him, Christine Blasey Ford, testified before the Senate Judiciary Committee on the same day. She showed up that morning and testified for hours, and then he showed up that afternoon and testified for hours. And similar to the Clarence Thomas case, there are people, divided to this day. Some who believe her, some who believe him. After the committee heard the testimony, it sent his nomination to the full Senate on an 11-10 vote. And then the Senate eventually confirmed his nomination 50-48, razor thin. And he's on the Supreme Court now. Amy Coney Barrett was also controversial, but in a different sense. No one accused her of sexual harassment, thank goodness. But what was controversial here, again, she was replacing a very liberal, iconic justice. Ruth Bader Ginsburg had been a very liberal judge, and of course Amy Coney Barrett was going to be a much more conservative one, probably. It was September the 26th, 2020, so less than 2 months before presidential election. And 4 years earlier, Barack Obama had nominated someone to take a seat on the Supreme Court, Merrick Garland, 9 months before the end of his term, so I think it was around the summer of 2016. And the Republican-controlled Senate had refused to hold hearings on the nomination. They had just said no, which has been done before in the history of the U.S., but they said, we're going to wait and see who wins the election. And then whoever wins, if it's a Democrat or a Republican, they can nominate somebody and we'll hold hearings then, but we're not going to hold hearings on Merrick Garland. And so Trump was accused of hypocrisy, or the Senate Republicans, rather, were accused of hypocrisy, because they did have hearings and they confirmed her nomination rather easily, 52-48. Well, it wasn't easy, but it was quickly, I should have said, rather quickly, 52-48. This is the latest person to be appointed, Ketanji Brown Jackson. So far, this is the only Supreme Court justice that President Biden has been able to nominate. There was really only one, there really wasn't that much controversy about her. So the only real source of controversy, and it really wasn't that much, was that before announcing his choice of this woman, Ketanji Brown Jackson, President Biden had announced that he would not consider any nominees unless they were black women. And so some people consider that kind of strange, possibly racist or sexist, not to even consider someone who was not a woman or not black. But that was his decision. And eventually she was the one that he selected. And she was confirmed by a 53 to 47 vote. Pretty close. Right? Mostly Democrats in favor and Republicans against.